What's up, Crim Heist? So, I am back again for another educational video. So, i-continue lang natin yung discussion sa Philippine Criminal Justice System. So, dun sa aking first upload is diniscuss na natin yung part 1 ng Philippine Criminal Justice System wherein diniscuss natin doon yung overview and yung mga bases and the definitions. So, all about the brief discussion lang siya about the Philippine Criminal Justice System. So, for our second part, i-discuss natin yung pillars of the Philippine Criminal Justice System. So, for the pillars of the Philippine Criminal Justice System, just to give you a heads up, since this subject is overview kasi siya ng mga subjects pa sa criminology. So, madadaanan natin yung CLJ. So, madadaanan din natin ang LEA or Law Enforcement Administration. So, para for the sake lang na magkaroon tayo ng idea, bibigyan ko lang din kayo ng brief overview or the simplest discussion about the pillars, the functions of each and every pillars na meron ang Philippine Criminal Justice System. So, by the way guys, I am Prof. Sean Francis San Diego, so also known as the Professor. So, I would like to welcome students of criminology program, graduates of criminology, and also registered criminologists na nanonood sa ating video para, ma-refresh lang sila about the topics in criminology. So, bago tayo mag-discuss, please don't forget to like, comment, share, and subscribe to the Professor, and hit the notification bell for you to be updated for my new upload. So, bago tayo mag-discuss, i-promote ko lang din yung aking libro. So, ito yung Research Procedural Manual for Criminology. So, isa ako sa mga co-authors ng libro na yan. So, yung one book na yan is composed of 546 pages. So, kasi siya ay 6 books in one. Meron tayong qualitative, quantitative with statistics, mixed method, multi-method, action research, and evidence-based. So, lahat yan naka-align for criminology program. So, itong libro na ito is ISBN registered and copyrighted. So, makukuha natin siya for only 1,200 pesos. So, for orders, please don't hesitate to visit the Facebook page of Aliswag Lifelong Training Center or contact their or reach out to their contact number 0921-505-2583 or 0916-430-7729. So, ito po yung libro natin. So, marami pa tayong libro for Research Procedural Manual. Meron dyan tayo for psychology, for nursing, for teachers, and for graduate school or for graduate studies. So, yun. So, now, di-discuss natin yung 5 pillars of the Philippine Criminal Justice System. So, sinabi ko doon sa first video natin na meron tayong 5 pillars, namely law enforcement, prosecution, court, correction, and community. So, kung makikita natin sa ating PowerPoint, makikita natin dito yung pictures ng Philippine National Police, the Armed Forces of the Philippines, and the National Bureau of Investigation. So, guys, itong tatlong to is one of the law enforcement agencies of local law enforcement agencies na meron tayo sa Philippines. So, siya ay under the law enforcement pillar. So, next naman is the Department of Justice. So, yung logo ng Department of Justice. So, siya ay connected or under the Prosecution Pillar kasi ang prosecution po ay under ng National Prosecution Service. And the National Prosecution Service is under the Department of Justice. Third would be the court. So, for court, marami tayong types of court na meron sa Philippines pero ang highest form of court na meron tayo dito is the Supreme Court. So, mamaya i-discuss natin what are the different types of judicial courts na meron tayo dito sa Philippines. Next is correction. So, for correction, mahahati yan sa dalawa, institutional correction and non-institutional correction, which is also a subject sa criminology under the branch of correctional administration. So, may dalawang subject dyan, the institutional correction and the non-institutional correction. So, bibigyan lang natin siya ng overview. Kasi gagawan din naman natin sila isa-isa ng separate video. So, for correction, makikita natin si Bureau of Jail Management and Penology. And nandyan din si Bureau of Correction. So, for institutional correction yan. For the non-institutional correction, nandyan naman po ang Parole and Probation Administration, at ang Bureau of Pardons and Parole. And the last one would be the community. So, siguro, doon sa mga may idea about the criminal justice system, alam na nila na merong community pillar. Pero doon siguro sa mga walang idea about the Philippine Criminal Justice System, so yung mga magte-take pa lang or yung mga first year criminology students na papasok pa lang this coming school year, marahil magtataka kayo bakit kasali si community sa Philippine Criminal Justice System o bakit isa siya sa mga pillars. So mamaya i-discuss natin kung bakit napasama si community. So ito, Philippine Criminal Justice System. So ang first pillar natin would be the law enforcement. So si law enforcement daw, or the first pillar, is tagged or referred as the initiator of action, the prime mover. So bakit kaya siya tinatawag na initiator of action or prime mover? So based doon sa representation kanina or doon sa slide kanina, law enforcement is the first process. So Philippine Criminal Justice System is a process wherein pag sinabi kasi natin na process, may mga procedures or step by step yan. So the first step or the first process, or it is safe to say that law enforcement is the first process or the first step in the administration of Philippine Criminal Justice System. Kaya siya tinatawag na prime mover or initiator of action. So its actions and decisions essentially control or dominate the activities or functions of other pillars. So since siya ay ang first pillar, so siya ang first act, so siya ang unang gagawa ng action in relation to the administration of criminal justice system, lahat ng mga magiging decision niya and actions to be taken will have essentially control or dominate the activities or functions of other pillars. So ibig sabihin kung ano ang gagawin ni law enforcement, marahil or sigurado na ito ay makakaapekto sa mga other functions ng Philippine Criminal Justice System. Kasi yung, for example na lang is the legality of arrest. So basically, in the legality of arrest, kailangan maging within the Constitution, no, ang way of arresting ni police officer. And basically, siya ay i-validate ng susunod na pillar, which is the prosecution. So kumbaga lahat ng gagawin ni law enforcement ay makakaapekto siya sa mga gagawin ng mga susunod na pillars. Next is, what are the objectives of the first pillar? So ano ba yung mga objectives ni law enforcement? So first is crime prevention. So prevention and suppression of crimes have traditionally been accepted as the primary goal of the local police forces. So para maintindihan natin, marami kasi yung naguguluhan kung ano ba yung difference or what are the difference between crime prevention and crime suppression. So bigyan lang natin ng simplest discussion. So for crime prevention, from the word itself, prevention, pinipigilan ito na magkaroon ng krimen. So ibig sabihin, it is safe to say na wala pang krimen na nangyayari. So si crime prevention, ginagawa siya ni law enforcement para wala nang mangyaring krimen or para walang gumawa ng krimen. When we say crime suppression naman, from the word itself, suppression, sinusuppress niya yung kriminal. Basically, for crime suppression, meron ng krimen na nangyari, and the last resort or ang pinaka-remedy na lang na maaaring gawin ni law enforcement is to suppress the criminal or arrest the criminal or stop the criminal from doing the crime. So, yun yung pagkakaiba ni crime prevention and crime suppression. So, paano ba ginagawa si crime prevention? Para lang maintindihan natin. For crime prevention kasi, ang kanyang direct impact is the exclusion of opportunity. So, doon sa aking first upload, yung pinakauna kong video, diniscuss ko dito yung anatomy of crime. So, yung anatomy of crime is composed of the motive, instrumentalities, and opportunities. So, refer na lang kayo, lalagay ko din yung link doon. So, si crime prevention kasi, ang ine-exclude niya is the opportunity para gawin ang isang krimen. So, yun ang crime prevention. Siya daw ay ang primary goal of the local police force. Next would be criminal apprehension. So, kasama na siya sa crime suppression. So, responsibility din ni police officer or ni law enforcer para i-identify, alamin o kilalanin, hanapin at i-arestuhin ang gumawa ng krimen. So, siya ay ang may primary responsibility to identify, locate, and apprehend the offender or the perpetrator or the criminal. Next objective would be law enforcement. So, it is the basic responsibility of the police to enforce the law. So, di ba nga, ang first pillar is the law enforcement pillar. So, police officers can also be referred to as law enforcers. So, from the word itself, law enforcers, they are tasked or ang responsibility nila is to enforce the law. Siyempre, from the word itself, law enforcement, to enforce the law. So, next would be order maintenance. So, they say that order maintenance as the objective or function of the law enforcement is the most troublesome responsibilities of the police. So, bakit daw? Kasi ang order maintenance, mahirap mag-maintain ng peace and order sa magulong lugar. So, it would be troublesome for the police officer to maintain the peace and order doon sa community or society na mataas ang crime rate or magulo. So, it is the most challenging. Para naman doon sa mga may area of responsibility na mababa talaga ang crime rate, medyo vague yung function or medyo boring nga daw or monotonous yung pagkakaroon ng order maintenance. As we all know kasi guys, the area of responsibilities, different areas of responsibilities, ano yan meron yung mga different characteristics. Merong area of responsibility na magulo, may area of responsibility na tahimik naman. So, kailangan magkaroon ng different approaches si police officers or law enforcers. Next would be criminal investigation. For criminal investigation, it is one of the most vital participation of the police in the criminal justice system. So, bakit siya ang most vital or most important? So, si criminal investigation daw, naging importante siya or vital siya sa administration ng criminal justice system kasi, ayan talaga yung main task or ayan yung pinakaambag ni police officer sa criminal justice system. Bukod sa pag-aaresto ng criminal or yung criminal apprehension, ayan ang pinakaambag niya or yung pinaka-task niya is to investigate crimes para magawan niya na ng complaint and maipasa na ito or ma-endorse na ito sa second pillar, which is the prosecution. So next would be public service. So when we say public service, the police is the most visible of authority. So they are called upon to assist in situations. So situations such as mga emergency situations, mga funerals, may kaguluhan sa lugar. So nandito rin yung mga to provide VIP securities to banks and funeral escorts, location of missing person or property. So yan, siya talaga yung most visible symbol of authority na pagka may nangyaring krimen, talagang siya yung tinatawag, di ba? Pagka yung isang babae na nakawan sa kalsada, di ba? Tinatawag, tulong, tulong, police, tulong. So, because the police officers are the most visible symbol of authority. Next is traffic regulation and motor accident investigation. So, the police are expected to ensure road safety for both pedestrians and motorists and assists in cases of accidents and emergencies. So, sila rin talaga ang primary responder o sila ang nagre-responde or rather primary respondent in cases magkaroon ng traffic accident. So, yan ang isa sa mga objectives or function ni police officer. Second pillar would be the prosecution. So, for the prosecution, siya ang may task to determine the legality of the action of the law enforcer. So, yun yung sinabi ko sa inyo kanina na yung mga actions, decisions ni police officers, talagang magmamatter siya doon sa mga susunod na pillars. So, for prosecution, siya ang nagde-determine tama ba ang way of arresting the offender, tama ba ang way or ang process na ginawa ni law enforcers in investigating the crime. So, yan yung mga functions or ayan yung mga dinedetermine ni prosecution. Si public prosecutor din, siya din yung nag-e-evaluate ng mga evidence presented takes place. So, ito, ine-evaluate niya yung mga pieces of evidence na pinresent or in-endorse sa kanya ni police officer through criminal investigation. And the last one is the finding of probable cause to warrant prosecution known as preliminary investigation. So ano ba si probable cause? So probable cause is the existence of such facts and circumstances as would excite the belief in a reasonable mind acting on the facts within the knowledge of the prosecutor that the person charged was guilty of the crime for which he was prosecuted. So, yung probable cause daw, yun yung hinahanap ni public prosecutor through preliminary investigation. So, ano si probable cause? Si probable cause, ito yung existence ng facts and circumstances na makapagpapatunay na si respondent or si accused ay guilty of the crime being accused to him through the facts and circumstances or evidence presented by the parties. So, yung prosecution pillar din daw, ito yung process whereby accusations are brought before a court of justice to determine the guilt or innocence of the accused. So, dito pala kay prosecution, kaya nga preliminary investigation, magkakaroon na ng preliminary determination kung si accused ba ay guilty of the crime or innocent, bago pa lang dalhin or i-endorse sa court. So, next is the duties of a prosecutor. So, ang duties of prosecutor is to conduct preliminary investigation, to make proper recommendation during the inquest of the case referred to them by the police after the investigation of the suspect, and to represent the government or state during the prosecution of the case against the accused. So, lagi lang natin tatandaan na ang function or duty ni public prosecutor is to conduct preliminary investigation, to conduct inquest proceeding, and of course, to represent the government or state during the prosecution of the case against the accused. So, ano ba si preliminary investigation? So, mamaya, i-discuss natin yon. Ano ba si inquest proceeding? So, now, i-discuss muna natin si National Prosecution Service. So, when we say National Prosecution Service, so si National Prosecution Service, siya yung under, or ang public prosecutor or mga prosecutor's office is under the National Prosecution Service. And the National Prosecution Service is under the Department of Justice. So, si National Prosecution Service is the principal prosecutory arm of the government. So, lagi nating tatandaan pag nakita na natin sa tanong, it is the principal prosecutory arm of the government, therefore siya ay National Prosecution Service. Ang primary task ni Prosecution Service or the National Prosecution Service is to investigate and prosecute all criminal offenses defined and penalized under the Revised Penal Code and other special laws. So, ibig sabihin, ang jurisdiction lang ni National Prosecution Service is to investigate and prosecute lahat ng criminal cases defined and penalized under the Revised Penal Code and other special laws. So, next is preliminary investigation. So, pagka kasi narinig natin si public prosecution or public prosecutor, lagi nating ikino-correlate si preliminary investigation. Kasi yan talaga ang primary function ni public prosecutor in the administration of criminal justice system. So, ano ba si preliminary investigation? So, when we say preliminary investigation, it is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof shall be held on trial. So, ibig sabihin, sa preliminary investigation, ito yung inquiry or proceeding na ginagawa ni public prosecution to determine kung may probable cause ba. So, yun lang yung simplest definition doon. Preliminary investigation is an inquiry or proceeding to determine whether merong probable cause based on the facts and circumstances presented kay public prosecutor. So, pag merong probable cause, gagawa na siya ng information for the endorsement para masampahan na siya ng proper complaint before the court. So, it is required to be conducted before the filing of the information for an offense whereby penalty prescribed by law is at least 4 years, 2 months, and 1 day. So, ibig sabihin, ginagawa sa preliminary investigation if the penalty prescribed to the offense is 4 years, 2 months, and 1 day. So, kalimutan nyo muna yung monthsary, kalimutan nyo muna yung birthdays. Ito muna yung tandaan nyo, 4 to 1. 4 years, 2 months, and 1 day. Pagka nakita natin na yung penalty prescribed is 421, 4 years, 2 months, and 1 day, therefore, required siya magkaroon ng preliminary investigation. Now, persons who may conduct preliminary investigation. So, sino rin yung mga tao na pwedeng gumawa ng preliminary investigation? So, nandyan si provincial or city prosecutors and their assistants, national and regional state prosecutors, and other officers as may be authorized by law. So, sino-sino yung mga other officers na yan? It is important for us to know sino yung mga gumagawa ng preliminary investigation. So, nandyan yung Tanod Bayans, special prosecutors as authorized by the Ombudsman. COMELEC's authorized legal officers only for violation of laws with regards to sa election, mga election laws. And the last one would be the special prosecutors appointed by the Secretary of Justice. So, bago tayo dumako sa third pillar, alamin muna natin kung ano yung difference ni preliminary investigation and ni inquest proceeding. So, preliminary investigation, inquiry or proceeding siya to determine if may probable cause. And ang prescribed penalty is 4 years, 2 months, and 1 day. For inquest proceeding, ginagawa siya or inquest proceeding is an inquiry or proceeding to determine if the warrantless arrest conducted by the law enforcers or the arresting officer is constitutional or inaalam dito or yung legality ng the way of arresting the respondent or the accused. So, sa inquest proceeding, inaalam lang kung tama ba yung pagkaka-aresto na ginawa through warrantless arrest. So, pag warrantless arrest, inquest proceeding yan. Gine-determine yan kung tama ba yung warrantless arrest conducted by the arresting officer in arresting the offender or in arresting the criminal. So, the third pillar would be the court. So, ano ba si court? So, court is an organ of the government belonging to the judicial department whose function is the application of the laws to controversies brought before it and the public for administration of justice. So, ibig sabihin si court daw is a part of the government under the judicial branch of the government and ang kanyang main function is to apply laws para magkaroon ng pagkakasundo sa mga controversies or mga conflicts between two parties. So, in order for the court to solve or to resolve controversies between two parties, kailangan niyang i-apply ang batas. So, it is also the judicial determination of the guilt or innocence of the accused is under consideration. So, kung kanina, si law enforcement, ang kanyang function is criminal apprehension, crime prevention. For prosecution is the determination or the legal determination or the legality of the determination of the legality done by the law enforcers, the determination of probable cause, and the determination of the legality of arrest. Yun ay under prosecution. Ito namang si court is ito na yung judicial determination ng guilt or innocent ni accused. So, ano ba yung mga different judicial courts in the Philippines? So, the highest court would be the Supreme Court. So, the second would be the Court of Appeals and Court of Tax Appeals. So, nandyan din si Sandigan Bayan. Nandyan ang Regional Trial Court. Nandyan ang Municipal and City Courts. And ang Sharia Courts. So, gawa na lang natin ang separate video kung ano yung mga specific jurisdiction and functions or yung pagkakaiba-iba nitong mga judicial courts na meron tayo dito sa Philippines. So, next would be the criminal jurisdiction. So, for criminal jurisdiction, it is the authority to hear and try a particular offense and impose the punishment for it. So, ibig sabihin, criminal jurisdiction, ito yung nagbibigay ng authority sa isang judicial court para i-hear and try ang particular controversy and mag-impose ng punishment through application of laws. So, may tatlong requisites kasi tayo for the valid exercises of criminal jurisdiction. So, let us remember na meron tayong 3 types of criminal jurisdictions or requisites of criminal jurisdictions. So, nandyan ang jurisdiction over the subject matter, wherein the offense by virtue of the imposable punishment or imposable penalty or its nature is one which the court is by authorized to take cognizance of. So, ibig sabihin, si particular judicial court, meron siyang particular jurisdiction over the subject matter. So, for example, si Supreme Court and Court of Appeals, these are appellate courts. So, yan ang kanyang subject matter. Only for appellate courts or only for appeals. Ang municipal trial courts is mga cases ng mga municipal and city ordinances or violations ng mga ordinances and those punishment na merong below 6 years. And then above 6 years would be the regional trial court na. So yun yung jurisdiction over the subject matter. Meron bang jurisdiction o may karapatan ba yung judicial court na ito para i-hear and try yung particular case na yon? So next is jurisdiction over the person of the accused. So, the person charged with the offense must have been brought to its presence for trial, forcibly by warrant of arrest, or upon his voluntary submission to the court. So, meron ba jurisdiction si judicial court doon sa taong yon by virtue of warrant of arrest or voluntary submission? Kasi syempre, kung hindi naman siya na-serva ng warrant of arrest or hindi naman siya na-aresto, therefore, walang jurisdiction si judicial court over that person. And the next is jurisdiction over the territory. So for the jurisdiction over the territory, the offense must have been committed or any of its essential ingredients took place within the territorial jurisdiction of the court. So ibig sabihin, for jurisdiction over the territory, ang nangyayari kasi dito is that magkakaroon lang ng jurisdiction yung particular judicial court na yun if doon nangyari yung crime. So, for example, the Regional Trial Court of Quezon City. Pero ang nangyari ang crime sa City of Manila, sa Arroceros, City of Manila. Or sa Luneta na lang, Luneta. So, si Luneta, naka-situate siya, or Luneta is situated or located in City of Manila and not in Quezon City. And therefore, if the crime occurred or ang krimen ay nangyari sa Luneta, which is in the City of Manila, hindi siya pwedeng itry or walang jurisdiction ang Regional Trial Court ni Quezon City. Kasi therefore, ang filing of the case shall be done to the Judicial Court in the City of Manila or the RTC Manila. So it cannot be waived, and where the place of the commission was not specially charged, the place may be shown by evidence. So, the next pillar is the fourth pillar, which is the correction. So, correction is the branch of the administration of criminal justice charged with the responsibility for, tatandaan natin, for custody, supervision, and rehabilitation of convicted offenders. So, yan ang responsibility ni correction, to have the custody over the person, to supervise the offender, and to rehabilitate or to give proper rehabilitation programs to the convicted offender. So, ang purpose of which is preventing a repetition of the unlawful activities without the necessity of taking punitive action. When we say punitive action, ito yung mga penalties na talagang nakakasakit o ito yung mga inhumane punishments. So, rehabilitation and reorientation of those judicially found guilty will take place in the correction pillar. So, ano muna si penology? So, di ba naririnig natin yung word na penology sa isa sa mga bureau or isa sa mga tri-bureau, which is the Bureau of Jail Management and Penology. So, when we say penology, it is a branch of criminology which deals with the treatments, management, and administration of inmates. So, ito yung branch daw ng criminology or part ng criminology siya, which is ang kanyang function is to give proper treatment, to manage, and administer inmates. So, what is penalty? So, penalty is the suffering that is inflicted by the state for the transgression of the law. So, ibig sabihin, ito yung suffering or yung punishment na ginagawa or binibigay ni state due to one reason, due to the violation of the law. So next would be the theories of justifying penalty. So for the first theory is that the theory of prevention. So the state punishes the criminal to prevent or suppress the danger to the state and to the public arising from the criminal acts of the offender. So, ibig sabihin, ang state daw is nag-i-impose ng punishment or penalty doon sa criminal to prevent or to suppress the danger of the to the state. So, ibig sabihin, para ma-prevent yung reoccurrence or yung recommission or para ma-prevent yung paggawa uli ng krimen. Second would be self-defense. So, the state punishes the criminal as a measure of self-defense and to protect the society from the threat and wrong inflicted by the criminal. So, ibig sabihin, ang theory of self-defense daw is that ang state daw pinapunish or nag-i-impose ng penalty sa criminal as a way of protecting the state itself and also the members of the community or the members of the society. Third would be reformation. So, the state punishes the criminal to help him reform or to be rehabilitated. As we all know that the Correction Pillar, which I mentioned a while ago, its primary purpose is to rehabilitate and reorient convicted offenders for them to be a law-abiding citizens and once they are reintegrated to the community. So, ibig sabihin, si Correction Pillar daw, siya yung nagbibigay ng rehabilitation program, nagbibigay ng mga reformation program para mabago yung criminal or mabago si convict at siya ay maging isang law-abiding citizen na. Para once na serve niya na yung kanyang sentence, siya ay i-reintegrate na sa society or ibabalik na siya sa society. So, yun yung theory of reformation. So, the punishment is a way of reforming or rehabilitating the criminal. Next is exemplarity. So from the word itself, exemplarity, it will give example. The punishment will serve as an example to others. So the state punishes the criminal to serve as an example to others and to discourage others from committing crimes. So for exemplarity theory, may dalawang keyword dyan or word na maaari tayong gamitin para malaman natin na ito ay exemplarity. So, nandyan yung example or to serve as an example to others and to discourage others from committing crime. So, for us to fully understand what is exemplarity, magbibigay ako ng example. So, for example, nakita ko yung kapitbahay ko na naggumawa ng crime. So, kunyari, ang crime niya is theft. So, siya ay nangupit. So, dun sa theft, nakita ko na pagkagawa niya ng crime na yon, mga after ilang araw, siya ay nahuli na ng pulis. Nahuli ng pulis na prosecute and he or she was found guilty beyond the reasonable doubt by the court. So, nabigyan siya ng punishment. So, nung nabigyan siya ng punishment, nakita ko na doon sa pangungupit niya ng pera or ng pangungupit niya ng pera, for example, or ng wallet, nakita ko na nakulong siya. So, tinanggal niya kanyang liberty, a right to liberty. So syempre, nakita ko yon na nabigyan siya ng punishment, nakulong siya inside the correctional facility. That will serve as an example to me not to do that crime. So ngayon, na-discourage ako na hindi dapat pala talaga na hindi ako gumawa ng crime. Kasi yung kapitbahay ko, nung nangupit siya ay nahuli, nakulong, and nabigyan ng penalty. So, through punishment, na-discourage ako and yung mga kapitbahay namin na gumawa ng crime. So next is justice. So the state punishes the criminal as an act of retributive justice, a vindication of absolute right and moral law violated by the criminal. So ibig sabihin si justice, ito yung pagbibigay ng hustisya on the part of the victim, to the victim's family, and of course to the society itself. Kasi it will serve as a retributive justice or a vindication or yung pagganti doon sa damages na ginawa or na-inflict ni criminal not just on the victim but also to the state. Next would be the judicial conditions of penalty. So may mga judicial conditions pala in imposing of penalty, in the formulation of a penalty. So first would be judicial and legal. So, the penalty must be imposed by the proper authority and by virtue of a judgment as prescribed by law. So, ibig sabihin yung mga penalty na kailangan nating i-impose, these are penalties formulated and created or imposed by the proper authority, which is our government, by virtue of a judgment as prescribed by law. So, syempre, makikita natin yung mga karaniwang punishments or penalties in relation to violation of criminal laws sa mga sa Revised Penal Code and Special Penal Laws. Next is definite. So, yung penalty daw na kailangan nating impose must be specific and exact. So, kunyari, 6 months and 1 day up to 1 year lang. 6 months and 1 day up to 1 year lang talaga dapat. Kailangan siya ay eksakto at specific na nakalagay na yun lang yung penalty prescribed or imposed to him. Next would be commensurate. So, penalty must be proportional to the seriousness or gravity of the crime committed. So, kailangan proportion lang siya doon sa penalty na doon sa crime na ginawa mo at yung penalty na i-impose sa iyo. So, for example, ang crime na ginawa sa iyo is, ang crime na ginawa ni criminal, for example, is theft. Pero ang penalty na binigay mo is reclusion perpetua, which is a capital punishment. So, hindi siya commensurate o hindi siya proportionate with each other. So, kailangan sapat-sapat lang. Sapat yung penalty na i-impose mo doon sa crime na ginawa ni offender. Next is personal. Penalty must be imposed only to the person who actually committed the crime with no substitutes. So, ibig sabihin, kailangan yung penalty na i-impose mo is personal doon lang mismo sa tao na gumawa ng krimen. Wala siyang substitutes. Hindi siya katulad sa basketball or volleyball or any other sports na merong mga substitutions. Hindi po pwede, for example, na si Juan yung gumawa ng crime. Siya ang judicially found guilty beyond reasonable doubt. Siya ang dapat mabigyan ng punishment. But since best friend niya si Pedro nag-volunteer na siya na lang ang magpapakulong. So, hindi po pwede yun. Kailangan kung sino gumawa ng crime, sino ang judicially found guilty through a court trial, siya dapat ang ma-imposean or ma-penalize. The last one would be the penalty must be equal. So, yung penalty daw, kailangan must be applied to all who committed the offense. So, kailangan, kung grupo sila na 5 silang gumawa ng crime, 5 silang na dapat maparusahan. Next is 2 approaches of correction. So, may 2 approaches kasi na meron tayo sa correction. So, nandiyan ang institutional correction and non-institutional correction na i-discuss yan sa area of correctional administration. But for the sake of understanding, i-define natin siya at bigyan natin siya ng simplest discussion. So, for institutional correction, it is the rehabilitation or correctional programs takes place inside correctional facilities or institutions such as national penitentiaries and jails. So, dyan po papasok si Bureau of Correction and Bureau of Jail Management and Penology. Ibig sabihin lang ng institutional correction, from the word itself, institutional, yung correction programs, rehabilitation programs, reformation programs, ay gagawin po sa loob ng kulungan. So, yun lang yun. For non-institutional correction, dyan naman po papasok ang probation, parole, pardon, or any other community-based corrections. So, these are rehabilitation or correctional programs na gagawin naman siya outside sa kulungan. So, ginagawa siya sa community. Kaya si non-institutional correction, tinatawag din natin siya as community-based correction. So, we will have a separate discussion or a separate video on the detailed discussion of what are the jails, types of jails, what are the types of prisoners, what is probation, what is parole, what is pardon. So, gagawa na lang natin siya ng separate video para hindi kayo malito. So, the next pillar would be the informal pillar. So, sa 5 pillars na meron tayo, 4 doon ay ang formal pillar. Yung first 4, the law enforcement, prosecution, court, and correction. And community is the informal pillar. Since kahit tinatawag siya ng informal pillar, the community as a pillar is very indispensable in the system. Because in the absence of citizens' assistance, the criminal justice system will not be able to handle effectively the complicated task of preventing and controlling crime. So, ibig sabihin kahit siya ay isang informal pillar, kailangan hindi natin siya i-left out because meron din siyang importanteng trabaho or importanteng ambag sa administration ng criminal justice system through citizens' assistance. So, madadaanan kasi yan sa law enforcement administration, yung police community partnership, or meron din tayo dyan sa professional conduct and ethical standards, sa sociology of crime and ethics, yung public trust. Diba? So, it is really very important yung public trust or citizens' trust or community trust sa government. Because through citizens' assistance, the 4 pillars or the government itself can handle effectively or can carry out their duty successfully through assistance or the aiding or the helping of the citizen or the community. So, yung success daw ng criminal justice system, specifically the community pillar, will be based on the role performances of the following. So, nandiyan yung family, barangay, schools, government, private sectors or the non-government offices, church, and the last one would be the mass and social media. So, these social institutions in the community pillar will help in carrying out the duties and responsibility of the four formal pillars. So, thank you very much for listening and I do hope that you learned a lot from today. So, natapos na natin yung subject na Philippine Criminal Justice System. I already uploaded the first video which is the part 1 of the Philippine Criminal Justice System. Ilalagay na lang natin siya sa link down on the description box. I also uploaded na yung Anatomy of Crime and Human Behavior. Ilalagay na lang din natin siya sa link. Ilalagay na lang natin yung link below the description box. Doon sa description box rather. So again, don't forget to like, share, comment, and subscribe to the professor. So if you have suggested topics in the field of criminology na gusto nyong gawan ko ng video, so please comment down or put down in the comment box para makita ko siya at gawa natin siya ng video o try natin siyang i-explain in the most simplest form. So again, thank you very much. So ayun lang. God bless. And stay safe everyone. Good luck in the upcoming board exams. So yun. Thank you very much.